So tonight, right now, I have just printed, hot off the presses, a new complaint. This is a pretty potentially big deal. It may end up not being a big deal because it's kind of going to depend on whether or not the president tries to keep the National Guard here in Washington, D.C. or not. The word out of the House today is that they are not really that interested in spending any political capital and trying to do whatever needs to be done to extend past that 30-day deadline. And without that, in theory, the National Guard would have to leave relatively soon. But I don't know. It's who's, we got to see if somebody's going to enforce that sort of thing. So regardless, today the District of Columbia filed a complaint, and I was not sure whether they were going to do this. They've already filed one complaint, but it was over certain things that didn't stick around, so they kind of backed off a little bit. And that complaint is actually just sort of sitting there, and the judge keeps kind of tapping them like, are you going to withdraw this or what? But they filed a new complaint today, and I have put it in my shared documents. I'll repeat myself a few times because we're getting started slowly. That's why I'm sort of dragging, because we're getting started. By the way, if you guys wouldn't mind tapping a little bit, I would appreciate it. We'll get some people in here. But essentially, that's what we're going to do. We're going to look through this complaint a little bit, talk it through a little, hey Harambe, and see what's in here. Now, here's the deal with a complaint. The complaint is the first thing that gets filed in a case. It's we don't really think about this very often this way, but the reason we say plaintiff is because they're the one who files the complaint. Have you heard about the U.S. Court of Appeals for the First Circuit's decision? I have not. Is there a new one? If it just happened, I may not have seen it yet. I hope it's not big enough for me to... so, usually I'm sitting next to my computer and I can look at things while I talk to you. Tonight, I decided I wanted to change a venue, and so I'm sitting in what is, at the moment, a spare bedroom because nobody's living in here for right now. Probably somebody will be again soon. But, so I decided to use this room because it was quieter. And I just kind of wanted to be somewhere else. So I'm here today, but that means I don't have the ability to go look. Anti-non-binary passport policies. No, I have not. So I'll go check that out. It may have been filtered. Well, I do have. Let me see here. I have an older, my real iPhone is a very old iPhone. I'll share with your Substack 2 minutes. Okay. First Circuit. Just looking, guys. Sorry, give me 1 second. I just want to see. All right, I'll have to wait till that comes through. Okay, so now that I've got a few people in here, I'll sort of speed up a little bit. So I have this new filing. This is the complaint in the new DC case, where DC is pushing back against the presence of the National Guard in Washington, D.C. So this shirt is my U Street sandwich toss T-shirt. So the DC flag, if you've never seen the DC flag, it's based on the George Washington's family crest, and it looks like that. It's 2 red bars, 3 red stars, and so we tend to make all kinds of things that have the 2 bars and 3 of something else, and so this is 3 hands throwing a sandwich. And it's the 2025 first annual U Street Sandwich Toss. So yeah, that's the DC flag. It's on our license plates. I have had a DC flag hanging in front of my house since 2003 when I first moved here. I just really liked the flag, and we hung it up there. And this is probably the 8th or 9th flag we've bought that puts up there, because they all eventually wear out. But so we are going to go through this case, and I'm just going to kind of talk through it. I have not looked at it yet. I was reading this paper clipping. Washington was hiding his... Oh, yeah. I'm certain that there's a lot of interesting stuff about that. But so this I actually designed this shirt. It's over on where the place where you go to get the mugs. Over in my profile, you can also buy the shirt. I have a couple different ones. Anyways, okay. Thank you very much. I thought it was pretty funny. I'm also, by the way, particularly proud of this down here. I designed a sandwich throwing league logo, and I spent way too much time on this. But down here in the corner, just like it's not really paid attention to, but I spent way more time on this than on the rest of it. All right, so let's take a look at this. Oh, one more time. So the thing about complaints is that it's the first thing filed, and it's really very much one side's opinion. It is really very much one side's opinion. Now there are some rules about what goes into the complaint. I won't go into them too much, but there are some things that have to be said in the original complaint, or they cannot be brought up later. So this is pretty important. But anything that we read out of the complaint, you take with a grain of salt. And normally I kind of wait until we see some more filings before I start reading stuff, but I am intrigued to see what arguments they make, even though, like I said, we have to consider everything here. We have to take everything they say here with a grain of salt until we see some really solid legal arguments. They're not going to get away with totally making stuff up. Nobody's going to get away with that. The lawyer who signs this, by signing it, essentially puts their bar license on the line if they write something in here that is completely false. So they're not going to do that. But if there's something in here that's kind of on the edge, you just, in a complaint, you stay back. So the next thing that'll happen is that, so this is going to be, every one of these is going to have a number, every one of these paragraphs, paragraph 1, paragraph 2, and the next thing that has to happen is that the defendant has to file an answer, and they have to answer 1, my answer to paragraph 1, 2, my answer to paragraph 2, 3, my answer to paragraph 3, and mostly what you do is you just write something like, no, I'm not going to give you the finger, but you basically say, I disagree. We don't admit that. And you just move on to the next one. If you have something specific to say, you say something specific. Otherwise, you're just like, nope, we disagree. And so essentially, a lot of the time, the answer is just paragraph 1, we disagree. Paragraph 2, we disagree. Paragraph 3, we disagree. So writing answers can take a lot less time than writing complaints. So let's see what we got here. So they're going to start with National Guard troops from 7 states and the District of Columbia. Okay, so right off the bat here, over 2,200 National Guard troops are currently patrolling the district. I did not know it was that many. Considering that I've never seen a group of more than 8 of them, and in a single day, I would say on a day when I walked around and looked for them and walked all over the city looking for them, I would say I saw at most, certainly less than, let's say 6 or 7 different groups of them. To go from that number to 2,200, that's a big number. I am surprised to hear that. So they're carrying rifled, driving armored vehicles. The U.S. Department of Defense has directed these troops to conduct core law enforcement activities. So that is key, because remember, we just got that case out of California that says Posse Comitatus is a defines Posse Comitatus a little bit, and some of these rules don't apply here in DC that do apply in the states, but Posse Comitatus does. So what's up with the Harvard funding case? I'm going to talk about it in the morning. I've read the news, but I haven't read the case yet. I mean, I've read some of the other filings in the case before today, or before it just came out, but I haven't read the new one. The last thing I heard was what was it? Oh, there was something. The government filed something. Oh, they were trying to get it moved over into Court of Federal Claims, and it didn't sound like it was going to happen. Thank you very much. It actually is on. I was just talking about this. I designed this shirt, so if you are interested, it's on brinodc.com. But this is it's based on the DC flag, and it's my sandwich throwing shirt. Right, the 2025 first annual U Street sandwich toss. So, but yeah, brinodc.com has the link to the mugs and the shirts and stuff. All right, sorry, keep getting off topic. Alligator Alcatraz. I did see it, and I will probably get to it in the morning report. I was like, should I mention this? Because it's just saying that they're appealing it again, which surprised me, because I didn't think they were going to. But, yeah. Don't make me tell my grand jury. It sounded like, it sounded like it was kind of out the door, and then and the state of Florida was starting to take it apart. So I don't know why that suddenly changed. I'm making a wild guess is that that started to become a news story, and it started to look bad, and that started to put some pressure on. It may be related to Venezuela. It's hard to say. It's hard to guess the reasons. I am not going to make a video on the legality of the airstrike, because that is such a huge body of law that is so far outside of my wheelhouse. When you leave the continental U.S., you go into this body of law that I know nothing about. It is so far. There's so much more to know about that that I don't know, and I can. It's one of those things where, like, if you and I were talking, I would have some answers, but I don't want to speak as an authority, because I am just not on that area. I know a lot more, stuff inside the country, wheelhouse. Outside, we get into some areas where, but I will say that, here's the one thing I can say, the one thing I do know, is that the president's authority to really do whatever the heck he wants goes way up when you leave the borders of the country. To sort of tell the military to do whatever he wants goes way up. So, all right. And then the one thing I just want to question, that he has won 17-0 with the Supreme Court. No, he hasn't. You gotta watch the word won, W-O-N, not O-N-E. Winning. Most of these cases still have not left discovery. So, no, they haven't been won. So it's yeah. Rockland. I don't know the Rockland case off the top of my head. Oh, Rockland County, New York. That one is, again, that's, I don't know much about it. All right, I want to get into this. Give me a minute. Let's see here. So we have 2,200 National Guard troops. U.S. DOD has directed these troops to conduct core law enforcement, which we've now heard in the state of California they are no longer allowed to do. But other states other jurisdictions are going to have to enforce that rule for themselves. But they'll be able to use that ruling from California as kind of a basis for their future rulings. That's why, people ask me if that ruling was going to apply to DC. Not directly, but it gives the DC courts something to kind of hold on to. And the reason that, the guy who wrote that opinion in California was a former Supreme Court justice's brother. That guy knows how to write a case that's going to get through the Supreme Court. So he wrote that very narrowly in a way that would withstand scrutiny. So, okay, the president has placed them under the control of the nation's military leadership, which exercises day-to-day supervision over the law enforcement operations they have been designated to conduct. Again, that is, would be a violation in theory of Posse Comitatus. That is paragraph 1. 2. The residents and leaders of the District of Columbia have not requested any of this, but the president has determined that the district, which he has called a filthy and crime-ridden embarrassment, should be federalized, so that his administration can run it the way it's supposed to be run. He disregarded Congress's decision half a century ago to afford D.C. residents the powers of local self-government. So, again, we are not a state here in D.C., but we were granted something that was akin to our, a sort of self-government. And so, and that was by Congress, and he's sort of overruling that, is what they're saying. In so doing, he's run roughshod over a fundamental tenet of American democracy, that the military should not be involved in domestic law enforcement. And this is one of the big things I've been saying, is that even though this not every single thing going on here violates the letter of the law, as, kind of the general American sentiment, the idea of overruling a local population on control of their local issues does go against just the whole American ideal. So whether this, we'll get into it, but whether it violates specifically the letter of every single law is another question. But it definitely does violate, a fundamental tenet of being American. And that is one of the, lines that I've drawn as we've talked about this. So he says none of this is lawful, but I would say that sentence is legally meaningless, and since this is an opinion thing here, I would... defendant's deployment of the National Guard to police districts without the mayor's consent violates home rule. And then he's going to go into what home rule is, which is that we get to kind of manage ourselves. Congress gave the president no role in policing the district. What is more, the Interstate Compact, and this is something I don't know much about, but I feel like I need to learn more about. The Interstate Compact that Congress approved entitles the district alone to determine when to request emergency assistance, including National Guard forces from other states. Neither the president nor the military he controls may supplant these judgments. So I'm just learning a little bit about the Interstate Compact. And the Interstate Compact, because remember, these National Guards, although they can be taken into kind of federal control, they are the individual militaries of each state. If you think of all of these states as originating kind of as individual countries, each one has their own military, and that's what these National Guards are. But they don't always serve a military function. Sometimes they serve similar functions, like helping after a disaster or something like that. And so there was apparently this Interstate Compact that all of the states, every single state, I think, and territory in the District of Columbia signed on to, where the states would agree, hey, if South Carolina needs help, we can reach out to Illinois, and Illinois will send their National Guard at South Carolina's request, but only at South Carolina's request. The Illinois governor will send his but his state's private military down to South Carolina if they ask. And that is the Interstate Compact. But the thing that I just here learned is that that compact is not just an individual agreement between the states, but one that was approved by Congress as well. So we'll find out how much power that has is there precedent for what happens when the president directly defies the Supreme Court? That has only ever happened twice. One time, he defied the Supreme Court. The Supreme Court said you are violating a congressional law, and Congress immediately acted to change the law. So it was a short-term sort of thing, but you know, things were a little dicey there for a second. That was in 1856, 1865. I don't know, dyslexia. Lincoln. Habeas corpus. Right? Yes. No, maybe not habeas corpus. Anyway, whatever. It was Lincoln. The other one was Jackson in 1823-ish. And that one is just sort of a stain on the presidency to this day, and we don't really have an answer, and it was just sort of one of those things where everybody just pretended it didn't happen. So that is sort of the answer. We don't really know because it hasn't really happened very much. Hopefully we don't fully find out. Yeah, you and whose army is basically exactly it. He said, well, I heard the, famously said, I heard the Supreme Court's order, let's see them try to enforce it. I have not seen that about the DOJ, but I would be surprised to, who knows. Okay. Oh, by the way, would you guys tap the screen? We'll get some likes up. All right. So we went through that. Defendants command and control out-of-state. Let's see here. Out-of-state National Guard units when they are in state militia status. Violates the Constitution and federal law. So these National Guard units are still not federalized. That. Ooh, I didn't even think of that. Okay, so these are still under their individual state governor's control as they're sent there. I thought they were at least federalized. I didn't realize that. So that's even more interesting. The president has not federalized any of the out-of-state forces that he's foisted on the district. Federal government, therefore, may not lawfully command them or control their day-to-day operations. Ooh, guys. Oh, I don't know why I just sort of assumed that they'd been federalized. I didn't realize that. Does the president's oath serve as a contract? It serves as an oath to you. And the way that you enforce it is you have the people, oh, thank you very much, is that you have the people that you sent to Washington on your behalf enforce it, which is done through the impeachment process. So that's how that works. The defendant's actions flout Posse Comitatus and 10 U.S.C. 275, which enshrines the nation's foundational principle or prohibition on the participation of military forces in domestic law enforcement, absent the most extreme exigencies, such as an invasion or a rebellion. So there hasn't even been a suggestion of a rebellion here. The danger that such an operation poses to individual liberty and democratic self-rule is self-evident. These unprecedented, unlawful actions have subjected the district to serious and irreparable harm. Irreparable harm is kind of one of those things that you need. Oh, thank you for that. Thank you, Timeless Light. I appreciate it. It's one of those terms of art. It means, it means what it sounds like. It's harm that's being done and can't be undone once it's done. And something that is irreparable harm is something that gets like a special level of protection in the government or in the courts. No American jurisdiction should be involuntarily subjected to military occupation. The District of Columbia brings this lawsuit and obtain declaratory and injunctive relief. So declaratory relief is they want the court to say this is illegal. We want you to declare. Make a declaration. Injunctive relief is equitable. They want you to step in and stop them from doing it. So that is declaratory and injunctive relief. Huh? Ooh, finger heart. Thank you. Okay. So we're going to jump over. We don't need to hear who the plaintiffs are, who all the people are. Now we're going to jump forward to legal framework. By the way, if you guys, in my shared documents, which you can get to through this is not an appeal, this is a new case that was just filed by the District of Columbia. This is the complaint, and I don't usually bother with complaints, but I wanted to see what this argument was going to be, because it's, up until now I wasn't sure what the argument would be. If you want to get a copy of it, you can find it online probably, but I saved a copy in my shared documents, but it's a little bit nested, so I apologize. It's in National Guard, Washington, D.C., and then I think there's another folder that's like case number, or filing number 2 or something like that, because this is the second case they filed, and I wanted to separate it from the first one. Injunctive and declaratory relief, and this is just, I could give you an hour lecture, but declaratory relief, they will declare. We will declare that this was illegal. Injunctive relief is an equitable function. Equity, oh, yeah, I like that. Equity, in equity, the court is allowed to tell someone to do something or to not do something. So an injunction is equitable relief. They're going to come in and say either you have to do something or you have to stop doing something. Declaratory relief is they're going to declare something, which either means we declare that this is illegal, or it can also mean we declare that you owe somebody $10. That is declaratory relief. Even though it sounds like they're forcing you to pay $10, it's actually not. It's, for some reason, that's declaratory relief. We are on page 7 at the moment. We are starting the legal framework section. This is the legal framework about the National Guard. And this, I have been doing a lot of reading on this. So they're talking about some of these cases, and I've read them all cover to cover. They're very long, very old cases. Well, some of them are. I guess that one's not as old as I thought. But Perpich is a particularly interesting one. I think I did a video just on Perpich. So at the nation's founding, the framers divided control over state militias in order to protect individual liberty and the sovereignty of separate states. This was like a huge fight, trying to figure out how they were going to draw that line. Framers are it's kind of a generic term for all of the people who were involved in drafting the Constitution, that sort of thing. Oh, Ludecky. Oh, Ludecky. Oh, it's a good one. Actually, is it sitting right here? Yeah, literally, right here. There's Ludecky. Doughboy. Ludecky just happens to be sitting right at my feet. Okay. So the founding generation, oh, that's a nice way of saying it, strongly disfavored standing armies. And this was a big thing. They were really against the idea of having a Central American army. There was a big argument over it. And what really changed the fight, I guess, is that there was one situation that happened where a bunch of, let's say, rabble-rousers, whatever, group of people came together, and they were starting trouble, and they were in Massachusetts. Well, Massachusetts happened to be storing all of our country's powder, explosives and stuff. And they had it was out in Springfield, so it was kind of out in the middle of nowhere, or somewhere like that. It was out in western Massachusetts. And these guys realize that, and so they start marching towards there to take it all. And the only thing Massachusetts has is their local militia, their little local army. So they send this local army to try to defend it. First of all, there's not enough of them, and second of all, they're friends with them. So they're not really doing a great job of defending this stuff. And so that sort of changed the discussion in the federal government. They were like, we kind of need like a central army instead of just relying on all of these individual state armies. It's a nice theory, but we need like one central army that can defend our stuff, the stuff that we're all sharing, because, South Carolina has an interest in that stuff too, and they should also be able to throw in on making sure it gets protected. So Lucky Lancelot, I did not. Can you tell me what case it was from? Maybe I did. I don't know. So anyway, but it sort of changed the conversation a little bit, and they start talking about having a centralized army instead of just what would now be 50 individual armies that just get called up whenever you need them. But up to that point, that's what it was going to be. And so, but people were really unhappy with this idea. Very, very resistant to the idea of a Central American army. And that is why thank you, the Morning Report rocks. I appreciate it. What direction an hour away do you live? I used to live in Baton Rouge. That's why I totally lost it. Totally forgot what I was saying there. It'll come back to me in a second. Okay, so we got kind of fighting over whether to have these individual armies or a bunch of central armies. We end up kind of going in the middle somewhere. I know, Central American Army, Standing Army, that's what we end up with. I just can't remember what. I saw something and it sent me off. It's going to pop back into my head in a minute, and I'm going to go, oh! I know how this works. So they really didn't want this Standing Army. A lot of fighting over it, but they realized that they need something central. And so they basically come up with this plan. That's what it was. They're going to make the House fund the Army every 2 years, and that is the Allison, we're talking about the Harvard case. So I haven't read it yet, so I'm gonna read it before the morning report tomorrow, and I'll report on it. But I just haven't had a chance yet. Sorry. That's why the House of Representatives has to decide every 2 years whether or not to fund the Army. They have to start from scratch every 2 years. It's written into the Constitution, and that's part of it. It's because they wanted to give the House of Representatives a chance every 2 years to say, you know what? The Central Army is getting too strong. We don't want this anymore. And so that's to this day, every 2 years, the House of Representatives has to decide fresh that we are going to continue having a U.S. Army. But okay, so arguing back and forth about how we're going to do that, and that's why we end up with this. That's how we end up with so many things that keep the federal government from using this central army in the United States, which is why it's a little weird that we have it going on right now. At the same time, the experience of the Revolutionary War and the Articles of Confederation taught the founding generation that the steady operations of war required a regular and disciplined army under centralized federal command. And he's quoting Alexander Hamilton here. Now, Hamilton was always very much in favor of a big central army, but that was Hamilton. The Constitution, therefore, reflects a compromise. It reserves to the states the principal power over the militia, including the authority to appoint its officers, train its members, and govern such part of them. It also grants Congress the powers necessary to ensure that the militia is a professional force available for national emergencies. It states that Congress may provide for organizing, arming, and disciplining the militia, and for calling forth the militia, the famous calling forth clause, to execute laws of the Union, suppress insurrections, and repel invasions. That was put into Article 1. That's the Article 1 calling forth clause. The National Guard is the modern militia. It's governed by a statutory framework that embodies careful balance struck in the Constitution. In general, the National Guard units are under command of the states. State National Guard may be activated by its governor to perform state duties. National Guard units are also subject to general rules of organization. At the request of the President or Secretary of Defense, a state National Guard may be activated by its state governor to perform training or duty funded by the federal government with pay and benefits determined by federal law. That is Title 32 status. Do you think the Supreme Court will allow tariffs? I'm not really a fan of Hamilton's, but that's all right. We don't have to agree on. I think he's kind of a. If you guys saw my video on that where I really got into 1800, the election of 1800, that where things got really, really bad between Adams and Jefferson, so bad. They actually said that at one point there was a pretty broadly shared rumor that Jefferson was doing gross things with his dog. I mean, it was really bad, and that was mostly Alexander Hamilton. Alexander Hamilton, like, he was actually busted planting stories in newspaper, and it actually kind of ruined his reputation finally when he was sort of caught. So he was, up until that point, it was sort of suspected that he was doing a lot of this stuff, and then right at the end he got really busted, and it all kind of came out. So yeah, he wasn't a great guy. If all the stuff that if you watch the musical Hamilton, you see all the fun stuff in the front, but if you kind of watch what's going on in the back, you realize it's all there. You know, like all that stuff that's going on with, he's not a great guy. Yeah, Adams and Jefferson had this wonderful relationship. I love their relationship. The relationship particularly between Abigail Adams and Thomas Jefferson, who were like best. They were all really good friends. They used to hang out a lot when they were both stuck in England and France, and it just got ruined. Hamilton just destroyed it. Thank you very much. I designed the T-shirt. I'm pretty proud of that. And Burr's, you know, that's a whole other situation. Burr was also kind of in that same crowd, though, so I don't feel too bad for him. But whatever. It's not just the Federalists, by the way, but it is that there's one kind of side group of Federalists. It's why Madison and Hamilton started out really close, and then they like split because Madison was like, "Ooh, dude, no, there's something else going on here. I'm out." So anyway. In rare circumstances set forth in Title 10, the President can activate the National Guard, make it part of the federal military. So this is the Title 10 status. We've talked about this a lot over the last couple of months, and that's where you bring in the National Guard and kind of pull them in as part of the military. And there's a couple different places where you can do that, but these circumstances are limited to the most severe exigencies. They include cases where the state requests federal aid, to suppress an insurrection, or when the U.S. is invaded or in danger of invasion. So, the D.C. National Guard is unique because regardless of duty status, the President is always its commander-in-chief. And that is key. That's why D.C. is, among many reasons, why it's a little different. The circumstances with the President can call out the D.C. National Guard in its state equivalent militia status are circumscribed by statute. For instance, the President can activate the D.C. National Guard to aid civil authorities in the execution of laws only when there is a tumult, riot, mob, or similar disturbance, and the mayor, the U.S. Marshal for the district, or the National Capital Service Director requests aid. One of the D.C. National Guard's elements is the Joint Task Force, District of Columbia Joint Task Force D.C., a mission-specific entity that typically operates as an organizational umbrella. Now, again, here's the only problem. This is a complaint. So this is going to be very one-sided. So, oh God, okay, we've got another politician in here. I don't know how these guys end up on my page. Go away. Trolls and politicians. He can go away. There's plenty of places that he can go argue with people. That doesn't need to be here. We're reading law. This is interesting because it's law. Okay, so here, like I said, the problem with this is, you know, he is going to say that these are the laws, and these are probably laws. No, these are almost certainly laws. There's no question that these are laws because the lawyer would not put them here. He'd be in really big trouble if they weren't laws, but they may not be the only laws. He's writing down the laws that are his favorite, and you always have to think that. The complaint is like the first step in suing somebody. It's how you open the lawsuit. It's why they're called a plaintiff, because they are the complaintiff, the person filing the complaint. So So you just always have to be a little grain of salty when you read a complaint. Like I said, it's a law, and it's probably great information. When you read the answer that the federal government will respond, it's going to give only the opposite of this. It's going to give only the one law that helps its story, right? And that's what these look like. And then in the end, the judge is going to sit there and say, put it all next to each other, and say, okay, yeah, this is true and this is true. So which one? Yeah, and that's how we end up with an answer, or with an opinion rather, final order. All right, so now we move on to home rule in the district. Again, DC is a funny little place. We are we're like a city-state, like Athens. We are both. It's all one city and it's all one state, county, whatever it is. It's all one place. So, but we are not fully a state in the sense of having the kind of rights of a state. Constitution vests Congress with the authority to exercise exclusive legislation in all cases over DC. So Congress has total control over a lot of stuff here. And they have exclusive authority. Just kind of keep saying that. Would not interfere or attempt. Okay. For much of the nation's history, they chose to govern the district directly. Think, basically, oh, hey, Penelope, how's it going? And during that period, Congress established the DC Militia, which became the DC National Guard. So it was Congress, before we had our own deal. Thank you, Gigi. That came up with the DC Militia, that created the DC Militia, the DC National Guard. Congress also made the president commander-in-chief and gave him control over operations, appointments and commissions, yada, yada, yada. And that whole thing about during a tumult, riot, or mob, or similar circumstances, he can grant requests by local leadership to order out a portion of the militia he deems necessary. In 1973, Congress enacted Home Rule, which grants residents of the district the power of local self-government and authority over local matters. And Congress delegated their powers over the district. So like they have all the power, but they delegated them. Thank you very much. I'm having a lovely Thursday. They delegated all of that power to a DC government that Congress set up. Pursuant to a statute enacted by Congress, they created the mayor, the position of the mayor, and the ability for us to elect a mayor. Authorized residents to elect a mayor, vested with executive power, and a council vested with all of Congress's legislative powers. So Congress said, instead of us writing legislation anymore, we now give all of that power to a DC city council that will be elected by DC residents. Okay? Pursuant to a no, they can take that back anytime they want. They can take it back tomorrow. But this is the way that they've set it up. Pursuant to a statute enacted by Congress, the mayor's responsibility include preserving the public peace, enforcing laws, yada yada, appointing the police chief. Yeah, okay, we get it. Congress reserved for itself control over certain matters it deemed of federal concern, such as authority to enact legislation that concerns functions of property of the United States. So they basically kept control over federal property. But otherwise, they gave the people of the district the right to govern themselves. By contrast, they gave the president an extremely limited role in the district. The president can nominate a small set of district officials. In special conditions of an emergency nature, he can request that the mayor provide services of the police force, which is what we saw recently. And the Home Rule Act also states that the district government may not exercise any greater authority over the National Guard of D.C. than it did prior to Home Rule. So the president retains his role as commander-in-chief of the D.C. National Guard, only the D.C. National Guard. But apart from these limited powers, Congress gave the president essentially no authority to oversee the district or control its governance. again, this is all one side's take on this. This is what a complaint is. So, grain of salt. All 50 states, 4 U.S. territories have entered into... now we're going to talk about the compact. Okay, so again, I just learned about this, and I think it's really fascinating. I can't believe I've never heard of this. So all 50 states, 4 U.S. territories, and D.C. have entered into an interstate compact known as the Emergency Management Assistance Compact that governs deployment of non-federalized National Guard units between jurisdictions. Remember that these National Guard troops are not federalized. These are still under the control of their individual governors. Oh yeah, will you guys tap the screen? We're a little low. This is not Ninth Circuit. This is the new case that was just filed by the D.C. Attorney General. Just hot off the presses, just an hour or two ago. And I wanted to go through it because I think it's got some interesting stuff in it, but it's also going to give us some broader stuff. Have you dug into the archives for any precedent cases similar to this? Oh, yeah. Yeah, as a matter of fact, as Doug, I think, brought up, or Doughboy, sorry. This one I just happen to have sitting right here at my feet is Ludecky, which is a particularly interesting case about the Alien Enemies Act, but also has a lot of other stuff. I've been digging into this stuff for a while, but there are still some gaps in my read here, and this might fill in a little piece of it. I have a really big theory that I've been working on that if I manage to prove, I think I may end up submitting as an amicus curiae brief if one of these National Guard cases make it to the Supreme Court, because I think that based on everything I've seen, there is a piece of this argument that has been missing for about the last 40 or 50 years that was kind of accidentally glossed over, and I think it was a mistake, and I'm going to argue that it should be rectified. So, but I'm still making sure that I'm correct, but we'll see. All right, so there's this compact. Let's see here. Okay, so there's this compact. Oh, thank you, Gigi. I just got a thank you. Gigi sent me something. Thank you very much. Sent me support on my thing, so thank you. Basically, all of these states signed on to this thing where they agreed to send each other assistance. One sent. I'm skipping over the part where we repeat ourselves. The assistance compact specifies mutual assistance may include the use of states' National Guard forces in accordance with this interstate compact or by mutual agreement between the states. So if something goes wrong, we can send each other's National Guards across state lines. Once sent into another state, emergency forces come under the operational control of the state receiving assistance and shall be considered agents of the requesting state. Now that actually throws a wrench into this, unless I will see where he's going with it. Congress and the President assented to the Assistance Act in 1996, giving it status of federal law. Council subsequently authorized... okay, all right. Well, the Council of D.C. subsequently authorized the mayor to execute the compact. The mayor has been responsible for determining when to request the deployment of other states' National Guard forces in the district. Now, here is my problem here, guys. Does anybody see the problem yet? So, in every other state, who is the person who will say, hey, I need help? It'll be the governor, right? The person in charge. Let me see. Wait, let me try this one more time. The emergency forces, once sent into another state, come under the operational control of the state receiving assistance. and shall be considered agents of the requesting state. But I am not sure whether or not that would mean, yeah, the governor, except the governor in most states is the commander-in-chief of the local militia. In this case, the commander-in-chief of the DC militia would be the president. So, you are correct that the mayor probably is, and this is what they're arguing, is that the mayor is the one who calls, and so the mayor would be the one in charge. But I wonder, if I were the one writing the answer to this, that would be my argument in response, would be, okay, but when they get in, it says right here, once they get in there, they're, well, they're not federalized, Spirit, that's the thing. They were never federalized. That's, they are still being sent by their local states. And so that's, and this compact deals, in most cases, when you send a local state militia across to another state, it kind of becomes under the control of that local state, or that state you sent it into, governor. So I don't know, this just came out today and it says they are not federalized in DC. So I don't know, I can only go based on this. And that's why I keep saying, again, you read this with a grain of salt because it's a complaint, it's one side, but usually they don't misstate the facts because, again, the lawyer who signed this is putting their bar license on the line by signing this. So if they are mistaken, that's usually fine, but if they know something and they misstate it, I don't want to say lie, they could lose their license over that. It's called Rule 11, I think. It's the signature rule. When you sign something as a lawyer, you are saying, I have read this and I agree that this has my signature on it, this has my seal of approval. So, okay. Are you arguing or are you, okay. Well, I'll give you a minute, but watch it, because if you're here to argue, you can go somewhere else. Okay, but anyway, so that would be a really interesting counterpoint. So I don't know. We will see. Well, I mean, we'll see how that shakes out. Okay, yeah, you're gonna go. Bye. I don't know how these guys find me. All right, and then we're gonna talk about Posse Comitatus. Honestly, I feel like we've talked enough about Posse Comitatus. I feel like I've kind of killed Posse Comitatus. In that case, our subset of National Guard from DC federalized. So the DC Guard would not have to be federalized. It would be the ones who are sent from the other states that would be the issue. So it's the ones that are sent from, West Virginia, from, those guys sent their National Guard in here, but they never federalized them. They never pulled them, at least according to this, they never federalized them. They kept them part of the West Virginia Guard. So that means that when they came in, they did so under the assistance compact that we signed on to. And so they're kind of governed by those rules. And again, the Attorney General, who probably knows this better than I do, feels like the mayor is now in charge of them. If I were writing the counter argument, that would probably be where I would go with this, is to say that when they got here, they would have been under the control of the commander-in-chief of the local militia, which would be the president. So it's just an interesting, I don't know. This is just off the top of my head. I haven't actually researched this, but I'm just seeing, a hole in the logic. So, okay, and then they're going to go into Posse Comitatus. The one thing I will point out here, because this is different, a little bit different, is that it says here that during the 19th century, the U.S. Marshals increasingly used the common law power of Posse Comitatus, a Latin phrase that translates roughly to the power of the county or the power of the sheriff, to deputize citizens, including members of militias and the military, to aid in the enforcement of federal laws. In 1878, Congress rejected this practice and enacted the Posse Comitatus Act. So, that's interesting. But generally the idea is you can't use the military to enforce local law. And that was kind of what the big thing that came out of that Newsom v. Trump case was. Play for Newsom. I'm sorry. Sorry. Explain the local militia, please. So, local militia is the National Guard. In 1780, every state had its own military. And they were called militias. Militia, the term militia, I'm going to screw this up, but it's something like this. This is close to what militia means. It means a military made up of non-professional soldiers. That's not exactly it, but it's close. So each state would have their own little military, but they were dentists and writers and carpenters, and they also would drill as an army. So every state had their own militia. Well, they kept those militias, and this is kind of a big deal because as we're talking about having this centralized army and arguing over whether or not we should have a centralized army, one of the big counterpoints is that we will have these state militias to balance out the power of that centralized federal army, and that's part of where 2A comes from. And that's part of where the language of 2A comes from, is that those militias are supposed to be there to provide a contrary, a power that balances out the power of this federal army. So there's that. Oh, so yeah, that was the. That's what the local militia. It originally would have been. They basically changed the name to the National Guard. But it is still, from a legal perspective, the word militia and the phrase National Guard are interchangeable. Now, states are allowed to have both a National Guard and another militia. And is it better? Tell me if it comes back, if it came back, because the light's still on. Let me know if it's still out. Is it better, Harambe? Let me know if the mic's still working. Somebody tell me. I guess my text is a little bit behind. Can you guys? It's fuzzy. Well, I'll tell you what. Here's what I'll do then. All right. I don't know why. Let's try this. I hate doing this, but how's that? We'll just use the regular mic on the phone. It's just, sorry, you're gonna be able to hear a lot more street noise. So yeah, that's it. Basically, National Guard and militia are the same thing. That's the short answer. Okay. Well, tell me if it's better for me to do this or to switch back. So it's going to go into Posse Comitatus. I think we've talked enough about Posse Comitatus over the last few days. So then it's going to go into the allegations, which I think we can just sort of flip through the president has launched an unprecedented attack on the district's sovereignty. Always, when they get into the allegations, it's always going to be dramatic in the complaint. Less strict law, more. It's just sort of the way it goes. So we're going to see there's going to be a lot of drama right here in the next few pages. The president ordered the Secretary of Defense to deploy National Guard troops. Let's see. I'm just kind of flipping through here to see if there's anything that we really need to know out of this. I think we know a lot of this because, you know, we've been here. Yeah, all right, so he did it. Yep, he did it. Okay. We'll bring the military if needed, and then he did. Okay. Okay, so there we go. He deployed National Guard troops from 7 states. And let's see if they have some actual important facts here for local and federal law enforcement. Comparing the law enforcement actions to come in D.C. with those that have recently taken place in Los Angeles. In 2025, there was we quelled the protests in Los Angeles. We're going to get DC under control. Other states will contribute. I'm going to federalize the police that don't work. I'm going to bring in the National Guard. I'm going to bring in federal marshals. I'm going to bring in park police. I'm just kind of, this is just, he's quoting stuff. How different is it being in DC versus a state? We have less protection. Well, here's the thing. We have a lot of the same protections, but they're statutory. They're not constitutional, which is a little different. You know, they're not so foundational. So they're a little easier to knock out. Yeah, so it's just going to kind of talk about blah, blah, blah. The district did not request assistance from out-of-state National Guard. All of the National Guard units deployed in the district are... Let's see here. Okay, so here we go. So the defendants have seized control and command of the out-of-state National Guard troops. Like the DC National Guard, they are here at the request of the president. They've been integrated into the command structure of the Joint Task Force DC. So I think that is the problem. The out-of-state National Guard units should be under the command and control of their respective governors, not the federal government. So, and it just kind of keeps going here. So I'm kind of... You know, they're engaging in law enforcement. Okay, so we have some pictures here of them, you know, school buses and that sort of thing. I don't know where they are. 2,200 of them is a lot. That's a lot of people. I don't know how I'm not, you know, seeing them more. I don't know where they are. Oh, here we go. They're down in the metro. Maybe that's where they are. I guess there are a lot of metro stations. So maybe if they're in every metro station, maybe that would explain it. I want to double check something that from earlier. No, whatever. I just want to make sure of something. Maybe it's in total and they rotate. Maybe they're rotating. Maybe. Yeah, I don't know. But when I saw that 2,200 number, I thought, ooh. And again, once again, grain of salt. Big grain of salt. It's a complaint. You know, it's why I frequently don't read complaints, because they're, you don't read the complaint usually because it's not. It's just not a great source of information. It's better to wait a little bit. But okay, let's see. The president has made his intention clear to continue to inflict these harms. Defendants claim their conduct is intended to make D.C. safer. However, recent reports indicate that about 2/3 of D.C. residents say Trump's recent actions will not help combat crime. News reports confirm that the deployment of troops has given residents a palpable sense of fear. That is definitely true. And rendered them afraid to go to the grocery store. Definitely also true. One restaurant owner said it's an attack on the community. We're feeling the effects. Business owner, okay, but quoting one restaurant owner is not usually a great way to get facts out, right? Okay, now we're at the counts. This is what their claims are. 1, violation of the Administrative Procedures Act. Someday I need to do a full thing on the APA, but it's basically the internal law that deals with how things are supposed to run within the government when they're not running within the government. But that covers so many different things. The APA covers so much. And it's just sort of a... like whenever an agency, you have a problem inside of an agency, everything that goes on kind of inside of the government, before it gets to the court system, it's supposed to go through the APA. It's how you... yeah, it's just like... it's the gears of the of the engine of government. So it covers so many different things. But anyway, they're saying it's violation of the APA. And just so you know, this is something that I don't think they have to do. Maybe they do. But most lawyers do this. I actually usually didn't because I think it's annoying. And I don't see any reason to do it. But it may be a jurisdictional thing, like certain jurisdictions may require it, and so lots of people just do it. Heck, it may be part of the Federal Rules of Civil Procedure, and I just forgot. But I was filing in a state court all the time, and I know it wasn't part of the rules there. But whenever they start a count, they always start it with the words, whoever we reallege the foregoing paragraphs of this complaint. Basically, they're saying, so everything before this in this document, we are re-alleging at the beginning of this paragraph. Like, yeah, we got that. It's all nice and stapled together. You didn't have to say that. They always do it. An agency cannot take action that exceeds the scope of its constitutional or statutory authority. Okay. And the DOD, DOJ, and... USMS are all agencies. DOD, yeah, basically they're just saying they stepped outside of what they're allowed to do. Okay. And they're going to go through step by step and explain how they did that. Okay, another violation of the Administrative Procedures Act, arbitrary and capricious. Arbitrary and capricious, another one of those legalese things you hear all the time. A lot of these rules have a whole set of explanation. In order to start choosing things, you have to do it in a very particular way. Arbitrary and capricious means you didn't do it in a particular way. You just decided we're going to do it this way or we're going to do it that way because I feel like it. And you're not allowed to do that most of the time. Very rarely, actually, with government are you allowed to just say, I feel like it, because that is a recipe for favoritism and for cronyism and for giving contracts to your friends and things like that. So arbitrary and capricious is just it means that they didn't follow the rules. They picked arbitrary reasons for doing this or this, and the reason you're not allowed to do it is because we have these systems in place that require you to do, like, for example, if you're going to pick a contract, you have to go through a bidding process where you have everybody put their bids in and you pick the best bid. You don't get to just say, oh, I'm going to take my buddy's thing over here. And the reason is that you're not supposed to be able to pick your buddy. You're supposed to, you're supposed to pick the best one and you're supposed to pick the cheapest one. Or some combination of those two. Because this isn't your money. This is our money. So arbitrary and capricious is something you're supposed to avoid. So they're saying that an agency action is arbitrary and capricious where they fail to articulate a satisfactory explanation for its action, including a rational connection between the facts and the choice made. So, when an agency rescinds a prior policy, it must, at a minimum, consider the alternatives that are within the ambit of the existing policy. All right, so what are we talking about here? Let's see. So what are we talking? So DOD and DOJ fail to offer any explanation for deviating from the long-standing practice of not using the National Guard for law enforcement. Okay. All right. They fail to consider the risks associated with deploying the National Guard to support law enforcement and deputizing them as special deputy U.S. Marshals when they lack adequate training and expertise in law enforcement. Okay, all right, maybe a better argument. DOD and DOJ failed to weigh the benefits of implementing the deployment against the costs. So they didn't do a cost-benefit analysis, which would be kind of the opposite of arbitrary and capricious, right? They would be, actually doing like a systematic way of making a decision. That's what you're supposed to do in government, because it's not your decision to make. It's ours, and you're making it on our behalf. So you're supposed to follow some sort of a system. So it created confusion among district residents and visitors about who was actually policing the district, what powers and duties they may lawfully exercise, and the corresponding threat that the exercise of such powers and duties will cause to public safety. They failed to weigh the risks of authorizing thousands of National Guard troops to carry semi-automatic weapons. Okay, yeah. Or the costs of deploying large armored vehicles on district streets. And they also failed to consider other relevant factors, such as the threat to the independence of the state National Guard units, the harm their actions would cause to military readiness, and the extent to which deployment would render units unable to perform other state or district level functions. So, while these guys are tied up doing this, they can't be doing other things that they might be needed to do. So they say acted arbitrarily and capriciously. Count 3, separation of powers and take care clause. Oh, we're back to the take care clause. That was one I was talking about the other day. Let's see here. They all place limitations on the exercise of executive authority. Separation of powers is foundational and evident from vesting certain power. They violated these constitutional doctrines by asserting authority over state militias. Okay. And we're coming back to Youngstown Sheet and Tube, which I just talked about, if you saw that. This court is authorized to enjoin any action by the executive and his agencies that is authorized by statute, exceeds the scope of constitutional authority, or is pursuant to unconstitutional enactment. That's Youngstown Sheet and Tube v. Sawyer, which is a great case. It's a very important case. Okay, and then we have one more thing. We're almost at the end, guys, which is that they acted ultra vires, which means outside of their powers. Neither the president nor an agency can take action that exceeds the scope of their authority. Federal courts possess the power to grant injunctive relief when they do, and defendants have taken actions in the absence of any plausible constitutional authority in plain violation of the limits imposed by Congress, and have impermissibly asserted control over the Guard units, in-state militias, and yada, yada, yada. So, with all that in mind, they ask for this one little page at the end here, this prayer for relief, where they say, this is what we want. We want you to say, to declare, declarative relief. Thank you, Allison. Thank you. I made it myself. Well, I didn't make it myself, but I designed it. Declarative relief. They want you to declare that deploying National Guard troops, that they've acted contrary to the Constitution by deploying National Guard troops, by exercising command of out-of-state National Guard troops, by deputizing members of the National Guard, by ordering the troops to carry service weapons, by placing DOD officials in operated... in charge of law enforcement activities, and so that's the declarative relief, and then the injunctive relief is they want them to enjoin the actions and stop the actions and vacate the actions, and then award any such additional relief as justice may require, which is a nice little thing to throw on at the end, and I've done that before to just kind of close things out. Well, that was it, guys. We just went through a 52-page filing. That was a lot. So that is what DC says is the root of this. That one lone DOJ attorney, I know, right? Poor guy. Just getting killed. Yeah. Oh, excuse me. So yeah, he's that poor guy. I feel very, very bad. But I had to go through this anyway, so I really wanted to see what I was going to talk about, so I thought I'd do it with you. I get why some of my friends jumped to law after engineering. Yeah, they actually have a very similar... I feel like it's all those very logic-based things. Which one's still left? I don't know. Oh, thank you! I like that. Funny, I'm sitting... So, for those of you who came in late, normally I'm at my desk. I decided we have nobody living in this room right now because we're just between people living here. Which DOJ attorney is still... It's... I don't want to say his name because I don't want to call attention to him. But it's just... There's one guy who just... was just getting hit real hard. It was when I saw him specifically file something and say... Sorry. Ambulance. Specifically say... I can't be there because I have to be in 3 different states tomorrow, that I realized, oh, it's really him. Like, I thought maybe it was just the name at the top and he was just signing it. And that was the day that I realized, because in one of the filings, it was just his name. And he was like, I can't do it because I have to be in California and Maryland tomorrow, which is already impossible. And I was like, oh, that poor guy. So... Anyway, so I decided to use this room because I just kind of wanted to be in a different room. Thank you. Different direction. So I sat here, but it did make it. It's probably a little bit louder. This is on the front of the house, so there's a lot more traffic here. Okay, well, so we got through that case, and that was really the goal for evening. I still have to write my script for tomorrow. Oh, and now I really have to go read. Everybody keeps telling me about Harvard, which means it's gonna be. I still have a couple more cases to read then. What is that? I can't see. Breakers, you sent me something cool, but I can't quite tell what they are. No, I did not see that. We'll make a note. I'll look that one up. But they're desks. Okay. Yeah, well, so normally I'm sitting at my desk, and I just decided, screw it, we're sitting here today. There was also stuff going on in the back of the house, and I was either gonna have to kick people out or find somewhere else. So I decided to find somewhere else. Oh, this is under my stickers. Okay. I just got, these came in the mail today. So for you, those of you who don't know, I have to find ways to make this sustainable, because I'm just doing this right now, and it is, living is expensive, and I can't afford it. So I decided to see if I could find some things that would be worth people helping me out with. And so I designed this t-shirt. It's for sale on brownodc.com, and I also made this is the logo from right here on the t-shirt that I made into a sticker. And there's some other stickers. that are for sale. But they just came in the mail today, and I'm waiting. My mug. Somebody got theirs. Somebody texted me and said they got theirs, but I haven't gotten mine yet. I'm still waiting on the the one that I ordered. BrynoDC.com. BrynoDC.com. Yeah. So but I'm waiting on my mug. My new mug, which I'm really excited about because it's got my duck, it's got my Aloha, and I especially wanted it for tomorrow because tomorrow's Aloha Friday, and I made an Aloha duck, and so I've got a mug with an Aloha duck on it, and then it says the morning report on the other side, and I'm so excited about it, and it's not here yet. I was really hoping it would be here today so that I could have it for. Thank you very much for Aloha Friday tomorrow, but. It's not here yet. Unless, it may come later tonight. I don't know. Heck, it might be. It might have come while I was talking to you guys. But I'm super excited about my Aloha duck mug. And I think it looks really cool. And I'm pretty excited about the shirt. I was definitely being a little silly when I designed this, and I realized that. But hey. But I thought it was, assuming that everybody has a sense of humor about throwing a Subway sandwich and the fact that, nobody got hurt. I do think the whole thing's a little funny. And so I thought this throwing Subway sandwich it's definitely like an iconic way to remember the summer of 2025 is the throwing the Subway. No matter what, that is something that we're never going to forget in DC. So, thank you very much. I appreciate that. So anyway, all right, I'm going to wrap this up for tonight, and because I still got, like I said, got to read the Harvard case now. So I'm glad I talked to you guys because I saw the thing and I was like, I just talked about the Harvard case like a couple of days ago. I doubt it's really that important. So now I'm going to stop and go read it before tomorrow and get something written on it. So this is part of the process. Anyway, all right. Thank you guys very much. Have a great evening, and thanks for watching. Come in, check me out tomorrow for Aloha Friday. Get to put my good shirts back on. All right. Bye, everybody. Good night.